All rise.
Oyez, oyez, oyez. Anyone having business for the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King, the Honorable Justice Hennessy presiding. Please be seated.
Morning, all. Ms. Barkley.
Good morning, Your Honor. Are you ready, Your Honor?
Yes. Thank you.
Thank you. Your Honor, you will recall when we broke yesterday, I had reviewed with you some of the evidence demonstrating that Canada was aware of requests by the Anishinaabe for petitions or for increased annuities that were not limited to $4. And I took you through, or reminded you rather, of the evidence that Mr. Schachter pointed out to you from the Fort William First Nation to Canada's Governor General at the time, Simon Dawson's letter that was sent to federal cabinet ministers enclosing that petition, and federal Indian agent Skeen, Charles Skeen's communication to his supervisors in the Federal Department of Indian Affairs. And of course, it's important to recall the evidence that was led in June by the historians that the court, or rather that Ontario did not receive this information directly, that this communication had been sent in each case to Canada. I want to turn then to some of the other surrounding circumstances and develop them further with you. Your Honor will likely recall that the subject of increases above $4 had been given some thought internally within the federal government. And I'm referring here to evidence that Ms. Jones testified about respecting correspondence between the Deputy Superintendent General of Indian Affairs, Lawrence Van Coonet, and Deputy Minister of Justice, E.L. Newcomb. If we could turn to our compendium, that's Exhibit MM, and turn up tab 13. Now, while people are pulling that up, I'll just mention as well that Deputy Superintendent General, that's a senior position in government. It's what we would refer to as a deputy minister today.
Thank you.
This letter goes, as I said, from Mr. Van Coonet to Mr. Newcomb. And he starts the letter of June 17, 1898. He says, "Sir, referring to the matter of the annuities payable under the Robinson Treaties," describes them by Huron and Superior in date. I also have highlighted sidebarred, which will form, if they have not already formed, a subject for consideration by the arbitrators who are at present considering the claims against the old province of Canada. So Ms. Jones, you'll recall her testimony, I'm sure, opined that this was written, of course, given the date and what Mr. Van Coonet is setting out here, in anticipation that these annuities would be part of the statutory arbitration panels that had now been struck and we're proceeding with.
I'm just going to ask you something. You will want me to consider this when I'm considering the evidence.
It's certainly my submission, you should.
And I'm guessing that what you read would be agreed by counsel here as a correct reading of this handwriting. So if you wanted to prepare, circulate to them transcription of the top of this letter, that would be very helpful.
I'm certainly happy to prepare that. In fact, Your Honor, it may be, I'm pausing because I might have actually seen myself a copy of a transcribed version of this. When I was preparing my submissions, I was going to Ms. Jones's documents, and she made very clear in her testimony that she prefers the originals whenever possible.
I recall that.
So I will certainly check, and I'm happy to prepare a transcription and to circulate it to my friends if we don't have one.
My worry is that I will not get it right.
I appreciate that, Your Honor.
Okay.
We will make note of that.
Thank you. And I do recall the careful historian preferring originals, but
Yes, Ms. Jones was very particular about that. So he goes on, and if we might turn then to page 58 of the compendium, the same tab, tab 13. He then talks about further increases because, of course, when this letter is written in 1893, the increase to $4 had already been taken. And then we can go down, Ms. Glasser. I'm at page 58 of the compendium. Is it possible to blow it up a little bit? This will also be something that you will appreciate a transcription portion of, I'm sure.
well, this may not be so easy to transcribe.
I think I have it, and I'm sure my friend will correct me if I misspeak. The way that I read it, Mr. Van Kunit is saying to Mr. Newcomb, but it is considered owing to the immense revenue derived from the sales of land and timber within the territory ceded by the Indians under the above treaties, speaking of the Robinson ones, to the Crown, the amount of annuity might further be increased to such further sum. It's not further because further is different, but it might be.
First,
I'll look for a transcription or I'll blow it up. But he's certainly talking about it being increased to such further sum as HM, Ms. Jones described to us that stood for Her Majesty at the time, may be pleased to order. And you'll also recall Mr. Newcomb, Deputy Minister of Justice Newcomb response. You'll be happy to see that I do have a transcription of that at page 14.
tab
Oh,
14.
excuse me, tab 14, thank you. Page 61. Now, in what I might call a rather curt response, Deputy Minister Newcomb acknowledges receipt of Mr. Van Kunit's letter. He says that he's aware of it, but in which it's not something maybe that could be the basis of a legal claim against the province of Canada.
Right.
And then you heard also that nothing, Ms. Jones said that she found nothing in her review of the documents that suggested that anything further had come of it, except for, she said, Mr. Van Kunit's early superannuation. In addition, the court also heard evidence respecting the exchange at the hearing that led to award number 3 between Justice Burbidge and Canada's Solicitor General, Mr. Curran. Now, Justice Burbidge, both historian Messamore and historian Jones, Professor Messamore and Ms. Jones told you, had been a former Deputy Minister of Justice of the federal government, and he had participated in and attended October 1884 meetings about the treaty and about the accounts generally. I'll take you to those in a minute, where the issue of, in 1884, it was leading up to the decision to enact statutes and strike an arbitration panel for the accounts. So he was, I would submit to you, aware of the issue. And in an exchange, which I'd like to go to at tab 15, at the bottom of page 65, again, that's our numbering. We've highlighted it for you. Mr. Burbidge, or excuse me, Mr. Justice Burbidge asks Solicitor General Curran about the responsibility for annuities above $4. And they have an exchange here. For Mr. Curran, he says that anything further than $4 would be something that Her Majesty would have to consent to, and that it might not be able to be charged to the UPC, the Upper Province of Canada's account. Should I continue? If Canada were to increase those annuities unilaterally. So again, there's this acknowledgement I would submit to you that more than $4 was a possibility.
In the eyes of more than $4 was a possibility in the conception of, or the thinking of, or in the eyes of
Government officials generally, but certainly of Canada. These are Canada's
the
officials that
Dominion.
are discussing it, or that are being asked questions about it and are making submissions about it.
Thank you. And Solicitor General Curran is a Dominion.
Yes, Your Honor. He was, that's a federal position. And in that role before the arbitrators, he was their litigation counsel. One of a group of people. So we say then that certainly Canada knew about this possibility. And I want to talk too about this concept of finality. And as I said yesterday, that the provinces were after finality. And I submitted to you at the end of the day yesterday that finality can only be achieved, it's our submission, through a final award that covered any claim for any increased annuities. So I want to discuss with you then how the provinces made this very clear. And the first thing that I'd like to look at, if we may, is at tab 20. This, Your Honor, is a letter that is, excuse me, this is a memorandum of sorts that is dated the 14th of October, 1874. And it's signed by the Attorney General of Ontario at the time, who was also the Premier, Mr. Oliver Mowat. And he was setting out why it was Ontario's position that the previous capitalization that you've heard an awful lot about, $88,000, that was taken or booked, if I may say that, in 1869, 1870 by the Dominion's Auditor General, John Langton. And that was done because all of the accounts were being placed before the Section 142 arbitrators. And here we see Premier Mowat saying, the question of the liability of Ontario in respect of the Indian annuities was fully discussed by respective counsel for the provinces of Ontario and Quebec before the arbitrators appointed under the B&A Act, and the undersigned is of opinion that the arguments which were advanced by counsel then representing Ontario and which were after war printed established conclusively that this province is not liable to be charged with the Indian annuities. And you heard also, and I'm realizing I don't have that reference, I will get it for you, that Mr. Mowat and Mr. Blake then had a correspondence back and forth about the annuity increases. And ultimately, Mr. Mowat on this basis was saying, we're not responsible, but we can deal with that on a without prejudice basis if you pay them now, and we can fight about it later. And in fact, we see that that's what they did through the arbitrations. So this is the basis of his opinion here. And this is 1874, some 4 or 5 years after the Section 142 arbitration had taken place. And I want to take you to something that happened 10 years later, where the exact same concept is being brought up by the provinces. So if we could turn, please, to tab 21. I'm going to take you to page 92. Yes, sorry. Page references, unless I misspeak, I will be trying to take you to the page numbers that we have put in.
Yes.
This is the transcript of the meeting that I spoke about just a moment ago. This was a meeting in Ottawa in October 1884 among senior finance people in the 3 governments. You heard evidence that it was attended by the provincial treasurers. Ontario's was Mr. Ross. Quebec's was Mr. Robertson, along with the Dominion finance minister. And this idea that Ontario and Quebec had understood to be true, that this capitalization of $88,000 had resolved all liability that they had to Canada for any annuities under the Robinson treaties, are brought up again. So we see Mr. Ross here making his argument at this meeting. It's at the page 92, my page 92. Mr. Ross says, with reference to these Indian annuities, the first point I take is that we are not liable at all for any claim for arrears under the Robinson treaties. That when the annuities were capitalized at $88,000, as they were at the time of the arbitration with the consent of the Dominion and the provinces, the Dominion assumed them at that sum, and that was a virtual settlement of them. They were assumed at that sum by the Dominion, and the Dominion ran the risk of any increase that might thereafter be claimed by the Indians. Over on the next page, we see Mr. Robertson beginning off the top of page 93. So far as Quebec is concerned, it appears to me that capitalizing these annuities at $88,000 was done in the statement of debt by the Dominion presented to the arbitrators ought to be considered as a finality, especially as the Dominion was notified by both Ontario and Quebec that no increase should be made to the debt without their consent. It seems too late in the day to bring up claims that were virtually settled years and years ago. There's an
in this excerpt, which you have just shown me, and in the one before, there's a reference to if the Dominion does things without consent, or if they do things unilaterally. What does it mean if there's a court order that there's a payment?
Well,
does that put it outside of the condition? If the Dominion does something unilaterally, if the Dominion does something without consent?
Well, at this point, what they're talking about are increases, because in 1884, of course, the increase had been taken to $4.
Yes.
And the provinces are saying, we're not responsible for that. We had gotten out of that through the 88 capitalization. And that if you want to charge that, you can't just charge our statement of account, because even in 1884, so many years, almost 20 full years past Confederation, they're still wrangling over trying to get these accounts settled. And I'll take you through when we go to the Constitution, but I'm sure you'll remember, Your Honor, the evidence about how important those statements of accounts were because the subsidies were being deducted. And so
Yeah.
they were fighting about that.
I just wanted to bring you to this concept that what they're on about
Mhm.
is the Dominion making increases
Yep.
without notice or without consent or unilaterally, and some suggestion that such a thing could be charged to the provinces.
Well, I think at this point, what they're saying is, look, we settled and we don't consent to being charged for further amounts. Now, in response to your question, can the court order it? Well,
No, I say if the circumstances are that the court orders it. I'm just trying to put it outside the circumstances which they define, or do you agree that a court-ordered payment of increases, retro increases, is outside their conception at this point?
I don't think that that's what they were talking about, and I'm not sure we have the evidence that shows what they would have thought about it. At this point, they were saying, we don't consent to you increasing our account anymore. And they ultimately do arbitrate about that.
We don't consent to you, the Dominion.
Well, yes, I would say that in the absence of a consent order, you know, the provinces are bound by a judicial order to do something.
I was just clarifying with the word you. We don't consent to you
Oh, yes,
being the Dominion.
being the Dominion.
Thank you.
And of course, as we'll see, the arbitrators do later say that this is something that falls within the debt. So it could be something that the Dominion can charge for. And then that gets complicated because of reasons that I'll take you to. So we have Mowat in 74. We have this meeting in 84. And then it's still, this issue is still going on, of course, in 94. And the provinces make these same arguments in November 1894, when they appear before the arbitrators at the hearing that leads to Award 3. And I'd like to go to that next. It's at tab 15 of our compendium. And I'd like to go to page 67. Again, our numbering.
Go ahead.
Thank you. At the top of this page 67, we see that it's Mr. Irving. Of course, we know Emilius Irving was counsel for Ontario on the arbitrations. And he's going through his position, his submissions, and he is actually talking about that meeting that I took you to. So he's going through the same positions and saying, you know, that there was this discussion 10 years ago. Goes through what Mr. Ross says. The first position I take in reference to the annuities under the Robinson treaties is that they were capitalized at the time of Confederation, and in the statement of debt submitted to the arbitrators, the amount as capitalized was stated to be $88,000. This sum was the amount at which these annuities were valued by both the Dominion and the provinces, and we claim that by so capitalizing them, the Dominion assumed the whole liabilities under the treaties at $88,000. And as if the Indian population had decreased, the Dominion would have had the benefit of the amount they would not, on that account, have had to pay the Indians. So now, on the contrary, we claim that in assuming a fixed amount, they ran the risk of any increase, and such increase, if any, must now be paid by the Dominion. So making the same argument. And then we see over the next page, Mr. Irving continues. He's still talking about that meeting. And he says about Mr. Ross, what Mr. Ross, again, the treasurer, 10 years previous, for Ontario said, you will see that under the treaties, there is provision made for an increase of annuity, but also for a diminution of the amount to be paid, but not for any increase in the numbers of the Indians beyond those named in the treaties. But importantly, he goes on and he says, now I contend that the Dominion, in assuming a fixed amount and capitalizing the annuities as they did at the time of the arbitration, is virtually settled. Mr. Robertson, Mr. Irving reads out. Mr. Robertson was the treasurer for Quebec in 1884. Mr. Irving notes to the arbitrators that Mr. Robertson had said, it seems perfectly clear to me that the sum of $88,000 was fixed upon the Dominion government. So again, he's presenting 10 years later that these are the positions. And we know, however, that in Award 3, the arbitrators rejected that position. The statutory arbitrators in paragraph 4, might actually be best if we turn that up as well. It's tab 6. Award 3 of 13 February 1895 begins at page 25, but the portion that I wish to direct your honor's attention to is at our page 26. Wait for the screen to catch up, Your Honor.
No, go ahead.
So we see paragraph 4, we've highlighted it. It talks about the liability to pay the increased annuity in any year before the union was a debt or liability which devolved upon Canada under the 111th section of the British North America Act 1867. It's on to say that this is one of the matters to be taken into account respecting excess debt calculation under the 112th section. But then it goes on to say, and I would say in direct response to the submissions by the provinces that they were not responsible, the arbitrators hold Ontario and Quebec have not, in respect of any such liability, been discharged by reason of the capitalization of the fixed annuities or because of
I
anything.
would so appreciate it if you gave it to me in your language and not theirs.
I'm more than happy to
would be
do that, but I never want to be accused of misstating it.
I will not.
The arbitrators found in paragraph 4, Your Honor, they divided, if you look at paragraph 4 and paragraph 6 of their award, they're talking about arrears at this point of any arrears that might be owing. And in paragraph 4, they talk about pre-confederation. In paragraph 6, they talk about post. Dealing with paragraph 4 first, they say any increases that could have been owed, any increases that are owed are in the pre-confederation years. So from the time of treaty to 67, they are 111, they are a 111 debt or liability. They go on to say, I've submitted to you in direct response to the submissions made by Council for Ontario and Quebec, that Ontario and Quebec didn't settle this through that capitalization. They're not off the hook, if I may.
Their debt has not been discharged by the capitalization.
A much more formal way of putting it.
Okay.
So it's not just the capitalization, but it's also then what happened in 73. In 1873, you'll recall, you heard evidence that all of the debt ceilings, all of the debt allowances were increased of well, it was now, I think, 5 provinces because Manitoba had joined in 1870. Everybody that had a debt ceiling at Confederation or upon their joining, in the case of Manitoba, were increased again across the board. And how that related to the UPC is that it went from $62.5 million, as stated in the section 112 of the B&A Act, to approximately 73. And I say approximately because it's a weird number that I never remember. Okay, so that's paragraph 4. So it says right in plain language, you didn't settle this. And I'm going to suggest to you that they implicitly say the same thing in paragraph 6, because while they don't refer to the capitalization and they don't refer to the Act of 1873, they say that Ontario alone is responsible for any increases that may be taken after Confederation. I said that was the paragraph that was post. So if Ontario is responsible, Ontario didn't manage a settlement some years earlier. That's how I read that. Okay? Is that
Very
helpful?
Thank you.
Okay. So continuing to put things in my own words, if I may, then, when I read these particular surrounding circumstances, and I look at these arguments that were put forth in 74 and 84 and 94, and that ultimately they get this award in 95 that says, you didn't do what you thought you had achieved. There's two sayings that come to mind. One is once bitten, twice shy. The second is paper the file. Maybe more well known to the lawyers in the room. Paper the file. Paper the file. And I suggest then that it's not surprising that when it came after all of this, with all of this background, and they get this award that says, you're not out. So when it came to settling the Robinson annuity payments as between the governments for all time, Ontario in particular sought to ensure that everyone knew that they were interested in achieving finality and in papering the file and making sure that the language was clear that that's what they were doing. I want to talk to you about that because, of course, there's evidence that you heard from the historians that we say demonstrates that that's exactly the steps that Ontario took. Now, I do have to step back for a moment, though, and I have to talk about that $8,200 because that, unless we're clear about what that meant and what that was doing, that other correspondence gets particularly confusing. So, you heard from my friend about the annual charge of $8,200. And that's in the OICs. $8,200 isn't language that's used in Award 15, the final award of the arbitrators. And Canada argues that the words, the annual charge of $8,200 demonstrates that the release itself was meant to be no more than $4 per person. And we say, of course, that that's incorrect.
Sorry, remind me, please, where do we see $8,200?
That's in the OICs, Your Honor.
Thank you. The final OICs.
Yes, the $4 is not in what I call the operative language. $8,200 is, and it's capitalized at 4% interest. It's agreed to, which the math gets you to $205,000.
Thank you.
But really, what we need to look at here is Ms. Jones' evidence in particular, because her unchallenged evidence at the time, or was that at the time, Canada was paying $4 to many more people than that $8,200 covered.
Right.
Her evidence was that in the time, there was approximately 5,000. The year that this was being done, she said there was 5,649 annuitants that had been paid. So the simple math is you take 5,600 and you multiply it by 4, 5,649, and you would have had to capitalize $22,596 if you were really trying to achieve a settlement of $4 per person for everybody that was being paid as of that time.
This is all about the dispute over the lists.
Yes, and that's what I'm going to take you to next, because that correspondence I said was important. You need to understand where this number is coming from. So capitalizing $22,596 achieves a much higher amount to be booked to the UPC account than 205,000, it would require 564,900. And it becomes very clear when we go through this correspondence that Canada would have known that that amount was absolutely a non-starter for Ontario and Quebec, because they were disputing even amounts that were slightly higher than the $205,000 that was ultimately agreed to be capitalized and charged to their account, or to the former account of the UPC. So I said to you yesterday, that number is a compromise. It's a compromise the way that settling parties compromise things. It never reflected the correct number of beneficiaries, never reflected an amount that was $4 per person. So why the compromise then? Why do that? Well, we know that settling parties compromise. They each look at what their risk is. They calculate the risk that they're comfortable with. And here, Canada took the risk that much more money might be needed one day. Much more money might be needed because of exponential population growth. Much more money might be needed because of how the resources in the territories might perform. Conversely, Ontario and Quebec took a risk as well. Their risk was that the population would diminish, that the territories might in some years not perform well enough that even $4 was a necessary annuity. And in either of those cases, that $205,000 that they were agreeing to be charged for might actually end up as an overpayment. So each party in each settlement everywhere, I submit to you, calculates the risks and they compromise. So with that in mind, then I want to turn back to
The risk of that it was an overpayment.
yes.
It's not a very high risk. You've already paid the money. You don't have any risk going forward except red-faced.
Well, the $205,000 was being booked to their account, that interest was going to be charged on annually, and that their subsidies were going to be deducted from. The treaty language, although it hadn't been exercised, the treaty language does provide a diminution clause if the population had, sorry, I apologize. The treaty language does include a diminution clause. And it's possible, of course, that the treaty territories don't perform very well. At the time, it might prove now to have been odd or completely erroneous, but they didn't believe that the superior territory was doing particularly well at all and had not for some years. None of us have a crystal ball. At the moment in time that they're looking at it, they're calculating the risks that might be on the table and that they were comfortable with.
Okay.
So with that in mind, then, I'd like to go back to some of that evidence. That once bitten, twice shy evidence. Now, you alluded a moment ago to the pay list issue, and that's an important one to keep in mind as well. Because what happens, of course, after the arbitration decision of award number 3 in 1895, we know that paragraph 4, the one that dealt with the pre-Confederation liability amounts, and which said that that was a 111 matter, that was not appealed. I will have more comments on that further, but it's important to keep that point in mind. We know that the paragraph 6 respecting 109 was appealed. That decision of paragraph 6 is February 13th, 1895. The Supreme Court of Canada, in something that it would never do so quickly nowadays, by December 1895, renders its decision overturning that decision and saying it's not a 109 matter. A year later, in December 1896, the JCPC agrees with the Supreme Court. So in 1898, January 1898, less than a year and a half later, a little over a year later, against this backdrop that 109 is not on the table anymore, Both pre and post Confederation amounts are 111 matter, subject to indemnification rights under section 112, but 109 is off the table. The arbitrators make an order. Not an award, Ms. Jones was careful to explain, but it was an order, it was a direction. And what the arbitrators say is that Canada bore the burden of demonstrating the entitlement of annuities for everybody that they wanted to charge the provinces for. So let me be clear again, putting it in my own words, what that means.
Or the burden of proving the list.
Yes, not that they had to bear the burden of, I wish to pay this individual. Canada can do that. Canada can pay, and we know has paid.
Proving the list, the legitimacy of the names on the list.
Well, I want to be clear that it's proving the legitimacy of the names of the list if they want to charge $4 for each of those people to Ontario and Quebec. So they can pay whomever they want. They can talk amongst internally who's on their list that they're going to pay $4 to. They exercise that right under section 9124. They administer the treaties. We know from section 111 that they're making these direct payments, and all the way up to the JCPC, they've been told that they have to. So they can pay whomever they want. But if they want to charge Ontario and Quebec's account, they bear the burden of proof that those numbers are accurate. That's the importance of that award, or that order, excuse me. So this then leads to another body communication. And it demonstrates this body of communication between Hogg and Irving, Council for Canada and Ontario respectively, and between Hogg and certain federal officials that he was reporting, to whom he was reporting. This all demonstrates that not only was Ontario scrutinizing those lists, they were questioning what they were being charged for and asking for proof that it was appropriate, as they're entitled to do, I suggest to you. But Canada also knew that this justification was being required and that it was a problem for them. So if we turn to tab 7.
Thank you.
Tab 7 is a memorandum of information that is written by Federal Justice Minister E.L. Newcomb, detailing information that he has received from Canada's Counsel, Mr. Hogg. It's dated the 20, well, it says that he's obtained the information on the 23rd day of December, 1898. And it's about the Dominion and provincial arbitration. So at the bottom of page 33, this is a reference. It will become more significant later in my submissions, but I'll point it out now. Mr. Hogg is speaking, or excuse me, Mr. Newcomb, Justice Minister Newcomb, mentions that Mr. Hogg has told him about the remaining claim against Ontario, Dominion's claim against Ontario with respect to the Northwest Angle Treaty, Treaty number 3, as it's more commonly or shortened formed. It talks about how that's still a matter that's outstanding. It's going to have to be dealt with. And then at the bottom of page 34, or rather the middle of page 34, he begins speaking about the Robinson annuities. And then at the bottom of page 34, he's memorializing the information in this memo that he received from Hogg. And he says, speaking about the number of Indians being paid, if strict proof be called for in each case, it may be troublesome and great delay may arise. But it is hoped that some general agreement may be reached which will obviate the necessity of taking evidence before the arbitrators. And if we turn to tab 8, Your Honor, this is a letter dated the 8th of March, 1899. Ms. Jones testified about this letter. It's a letter to Hogg, Mr. Hogg, from Mr. McLean. He was the Secretary of the Federal Department of Indian Affairs. And it is written, Ms. Jones explained to us, in response to Mr. Hogg's pressure to that department, the Federal Department of Indian Affairs, to produce a report for the arbitrations that were in line with the order of the arbitrators, that burden of proof order. And what Mr. McLean tells Mr. Hogg at the bottom of page 36, and scroll down a bit. Thank you. He says, it would be a matter of great difficulty, if not impossibility, to prepare an exact statement of persons entitled to rank as annuitants. Goes on the first full paragraph there. Mention may be made of the apparent undesirability on the ground of difficulty and expense to all parties of such an investigation. And he ends by saying that he's directed to say that the terms of settlement would be quite satisfactory to this department, that is the Indian Affairs. Now, I will point out that there's a reference to the Hurons in this. And again, at that point, that was because they were proceeding under the idea that the superior revenues would not be further increased.
Back to this. This is why I need you to do it in your words. Can you go back to this last line that you read before the signature line? And I am directed to say that the terms of settlement therein recommended would be quite satisfactory. Those terms are?
Well, at this point, we don't have the OICs. So what we do know from Ms. Jones's evidence is that some internal communication has obviously been happening and that there is a desire for settlement.
Okay, but we don't know what he's saying yet.
We don't have anything directly to point to,
Okay.
or if I was once aware of it, I must confess I've forgotten, and I can look into that, but I don't recall Ms. Jones providing information about it. Maybe my friend Ms. Glasser. She's pointing out to me that they are speaking of the arrears at that point. You'll recall, Your Honor, that when it was decided to be increased in 73 on Mr. Mowat, Premier Mowat's suggestion, it was pay them, pay the annuitants, and then we can fight about it. And so by the time we're in the arbitrations now, it's been paid. So there is arrears owing to the UPC's account, Canada would say, not to the Indians from 74 until this time. But then there was also the issue of whether there were arrears to the annuitants themselves from the time of 1850 to 74. So there's two different types of arrears. So then knowing these difficulties, though, with the pay list and with this burden of proof, and understanding that further scrutiny and protracted litigation was a possibility in meeting this burden of proof, we see that the parties move forward towards a settlement. And if we look, I've got two communication here at tab 9 and tab 10. They are identical letters dated May the 3rd, 1899. They are both from Mr. Hogg. The one at tab 9 is sent to Canada's Deputy Minister of Finance, Mr. Courtney. The one at tab 10 goes to Mr. McLean. And again, we've heard his name already today. He was Canada's Secretary of Indian Affairs. So I propose we just look at tab 9. In these letters, again, they're identical. Mr. Hogg writes about the Robinson accounts and the agreement that by this point in May 3rd, 1899 had been reached among the governments with respect to the amounts of arrears to be charged to the UPC. You'll recall that they had agreed as amongst themselves about the certain years that arrears were justifiable in on the basis of the resources that they had seen. But at the bottom of the page, Mr. Hogg lets both Deputy Minister of Finance Courtney and in the separate letter, Mr. McLean, Canada's Secretary of Indian Affairs, he lets them both know Mr. Irving has made his consent to the adoption of these figures conditional, settlement of arrears conditional upon the ascertainment of the amount which is to be capitalized for the future after the 31st December 1892. And it is important that this amount should be fixed so that the case may be brought to a close and finally disposed of. So Mr. Hogg is certainly aware, I would submit to you, that Ontario's position is any settlement about these arrears that we've been talking about, it has got to include something that's final for all time, something that takes us beyond the 31st of December, 1892. He's making it conditional. On page 40, same tab, Your Honor, I'm still tab 9. Again, this is Mr. Hogg. And he says, I hope it's highlighted for you. Yes, it's sidebarred. I find the provinces, plural, are anxious not only to have the subject matter which is immediately under the jurisdiction of the arbitrators, namely the arrears, brought to a close, but to have all outstanding matters relating to these treaties finally disposed of. And he goes on to talk about the issues that they've been having with trying to find a number that might be appropriate to achieve that settlement. And he goes on to say that it might be that the provinces are going to object to certain numbers. And we see ultimately at page 41 that it's his proposal that that number be set at what ultimately the numbers are that we see are brought forward into that capitalized amount of $205,000. So again, you know, it demonstrates, we say, the compromise and calculating the risk. And well, we could do this, we could do that, but this is how we think we can achieve this settlement. These are the numbers that we think will be successful.
When you say it demonstrates this position that Mr. Hogg is articulating or asserting?
Yes, but also that
I'm just trying to find out, what are you saying by it? It demonstrates that.
let me be more clear. I apologize. These letters demonstrate a number of things. The first is that Canada knew that in order to achieve a settlement on the arrears, the provinces were making that agreement conditional on going beyond that. It also demonstrates that there would be an issue with this burden of proof and the numbers that were being proposed for that settlement. It also demonstrates that this number of 2650, you see, I would suggest to you, Mr. Hogg's own internal thinking as counsel. These are the numbers that we can pitch. These are the numbers that we can justify to get this settlement achieved. So it's not that it's a $4 per person settlement. It is a number that is used to achieve the settlement. There's a nuance there, but it's an important distinction. So those letters are early May, May 3rd, 1899. If we could go, please, to tab 11. Now we have Hogg, Mr. Hogg, writing to Mr. Irving. This is also in May. It's later in May, I think that's May 23rd.
I just have one question on this 2650. 2650 is the number Mr. Hogg proposes as a population number. A number that is one factor in a multiplication times 4 to get to the ultimate capitalization number. And you say both parties knew, or Canada knew, that number did not represent how many people they were paying.
That's right.
And presumably Canada was paying more people because they thought they should pay them. They thought they should be on the list. And why do you think, if it's simply the capitalization, if the capitalization number is simply a settlement number, why go through this sort of smoke and mirrors thing?
Because I think what had to happen is that at the end of the day, they needed to have a number. They needed to have a number of the money that was going to be charged the UPC accounts, because all of these arbitrations were about settling the UPC accounts. So, but they also, being in government for a while, they also need to justify it within government. So they need to be able to say, well, what does this account for? Like, how many more people are we going to be essentially agreeing to be paying outside of this amount? What does this 205 mean? How many more are we going to still be paying? So when they look at this $205,000, they're doing the math in their own mind about what is the risk that they're willing to take on as to how many more that they're going to be out of pocket's not the right term, but paying in addition to any amount that they've now been indemnified for by Ontario and Quebec.
Okay, so let's say we accept. They've got to, they know that the number is not accurate in their minds.
Yes.
Given the numbers that they're paying. They know that, what is it, 2650. It's not the number of people they're paying, but they know one thing, that when they're talking to government, they're talking about $4. They don't say, let's pay 5,600 people $2 or 1,000 people $6. Whatever, what I'm saying is there's one fake number in here, that's a 2650, but there's a number that everyone seems to agree on is their outside number. That's why they're using it as a factor in the multiplication for the capitalization.
But they also know that there's possibility of more. And they're saying that they're going to accept.
You say that, and I'm okay to accept that that's your argument. But I'm saying for the purpose of reporting to government, as you say, they're using $4.
Well, they're using a number that they would be comfortable charging and only receiving indemnification for. This is the amount that they are comfortable settling for and giving up anything further. It's like a personal injury claim in a sense. What am I comfortable settling this for, knowing that I might have other injuries, knowing.
That's the bottom line number.
Yes, it is a bottom line number. And they're doing the math to figure out what are we comfortable getting the money back for? And what does it mean how much we're giving up? What, at least with what we know right now, today, what we're giving up. Because this number is always going to fluctuate. We've seen evidence of that as well, that in certain years, different numbers of people are being paid. And then just population being the way it is, it ebbs and flows.
Okay.
So if I may turn then to tab 11. Having written internally to people that he's reporting to about the settlement, Mr. Hogg, that is writes to Mr. Irving. I'm at page 46 of our compendium, Your Honor. And he starts off situating the letter. He's referring to correspondence and discussions that have taken place between the two men with respect to the final closing up of the Indian annuities claim before the arbitrators, and capitalization of the increased annuities after the year 1892. He goes on to speak about the agreement that has been reached respecting the arrears. We turn over to page 47. He says the total amount, therefore, Again, speaking of the arrears for which the award of the arbitrator should be made, $113,000. This award so made would finally close all matters in the Indian annuity case before the arbitrators. Again, that's about the arrears. Then he goes on and he says, the next question in regard to these treaties is the course to be adopted in regard to the future after the year 1892. He talks about different treaties. We go over to page 49. We see that Mr. Hogg is telling Mr. Irving, I have submitted the question of capitalization to the Department of Finance, and that department has agreed that the method is the proper course to pursue, namely capitalization, to bring this matter of payment of future increased annuities to a close as between the Dominion and the provinces. Again, he notes the number of 2650 was suggested to the department by myself as being fair and over. He concludes the letter. This one agreed to would finally close the whole Indian annuity claims forever. Speaking, of course, again, the claims that can be made on the UPC account. Now, these numbers differ a little bit because you'll recall that there was ultimately a compromise for the interest rate proposed. Everybody had a different opinion, 3, 4, 5. It's ultimately 4.
We don't need to do the year.
We don't need to worry about that, thank goodness. So he ends the whole matter to be charged Province of Canada account to answer for the future after 1892. Now, Irving responds to Mr. Hogg, and he does that, and I'm sorry, he does it in handwriting on tab 12. There's a number of things that he does address in this. He meanders a little bit, perhaps, in his thoughts. It's a letter dated 17 August 1899 from Toronto, Mr. Irving, to Mr. Hogg in Ottawa. The subject line is Huron and Superior Treaties. And again, thinking of this once bitten, twice shy, we see him making very clear what he wishes the orders in council to say, and he does that at page 54. He says, the draft order in council should embrace the following arrangement, namely that on the 31st December 1892, there should be the further charge to the account of the Province of Canada of $205,000. That's a capitalized sum taken to extinguish the annual charge. They wanted to be rid of the annual charge of $8,200 for all future annuities and relieve from all liability forever the provinces of Ontario and Quebec from any further payment which may be payable under the Huron and Superior Treaties of 1850. So against these surrounding circumstances that I've taken you to, we see that the OICs are signed and ultimately counsel for the 3 governments appear before the statutory arbitrators to request an order. And it's that I'd like to go to now. So we find that at tab 23. On June the 2nd, 1900, it seems that there was a set hearing before the statutory arbitrators to discuss some of the outstanding matters that were still before them. And we see the chancellor saying, in fact, that this meeting had been called to dispose of one matter, but several others have been put on the paper. Excuse me, Your Honor, I'm at page 100.
Thank you.
Let me step back. So page 100,
Thank you.
proceedings at Montreal, June 2nd, 1900. The Chancellor, that's Chancellor Boyd. The meeting is called to dispose of one matter, but several others have been put on the paper. The first is the claim of the Dominion against the province under the province of Canada under the Robinson treaties. Now, I'm going to pause there before I go on. My friend suggested to you in her submissions that Award 15 was unnecessary. I responded briefly to that yesterday. And she suggested that it was just done to tidy up the OICs. And she took you to a letter from Mr. Hogg to Irving, in which he mused that the OICs were sufficient and that an award of the arbitrators wasn't necessary. You'll recall that. Now, in fact, I think that what I'm about to take you through demonstrates that, in fact, by June the 2nd, 1900, all of the parties were very much in agreement that an award was necessary. Now, the provinces, of course, it was necessary, I suggest to you, because they'd been caught out in an earlier belief that had proven to be wrong, and they are papering the file. They want a final award. Everybody's legislation says that the final award of the arbitrator shall be binding on the respective governments. Doesn't say that about the OICs, it says that about the final award. So let's look at
in the OIC or in some other legislation.
Remember,
The
yes,
legislation says that
yes,
arbitrators
yes.
award will be final and binding.
That's what I took you to yesterday, and we'll spend some more time on it today, very briefly. When the arbitrations were being envisioned, because the years after the award of 18...
enabling.
That's right. Years after the award of 1870, they're still wrangling about this. They passed parallel legislation.
Thank you.
Okay, so just for your reference, it's section 8 of all of that legislation. It says very clearly that the final award of the arbitrators in writing shall be binding on insert government whose legislation it is. Section 8 of Canada's still in effect today, says shall be binding on Canada, save and except for an appeal, in which case that appeal shall be final.
Thank you.
Okay.
And I can call that the enabling parallel OICs.
No, I wouldn't do that, Your Honor, because it's not the OIC, it's the legislation.
Oh, it's parallel legislation. Thank you.
Yep. I call it the acts of 1891 that enabled the statutory arbitrations to proceed in the first place, to be struck and to proceed. How am I doing on time? Your Honor, I'm going to spend a bit of time going through the transcript. I'm happy to keep going. If you wish to have a break now, that's fine too.
Why don't you go for another 5 minutes, but try not to read me the transcripts.
There's some important things I need to take you to in the transcript.
Bring me to them.
I will take that under
Advisement.
serious concern and consideration. But I would suggest to you that particularly I need to read you some of it in response to what my friend told you.
Well taught by Ms. Jones.
All right. So here we are, a long time ago, just like we are today. Maybe somebody will be doing that 123 years from today. As Barclay said. So we have Canada's counsel, of course, Mr. Hogg. We know him well by this point. He starts off and he says at the bottom of page 100 that the Indian treaty matter, that is the Robinson ones, there's been an agreement now. The several parties have agreed on the amount to be charged to the UPC account. And he goes on to say, in addition to that, I may say that they have agreed to a capitalized amount to be charged, again to the UPC account, And here I'm at the top of page 101. Mr. Hogg says to be charged for all future annuities under the same treaties so that it will be a final winding up of the Robinson Treaty case. Final winding up, not only for the past, but for the future. He continues, talks about the arrears. The Chancellor asks him, is this completed? Is this distinct? Is this distinct from the other matters that we have before us today? And Mr. Hogg says yes. And he's asked again, what do you want us to do with this, essentially? And Mr. Hogg explains that it's one of the items on the UPC account, and we will then ask for an award upon that account. He's asking for an award. So while he might have mused a few months earlier, maybe we don't need an award, he's coming with the other on consent, the three governments asking for an award. He asks for an award. And he says, describes the middle of that block quote, the capitalized sum of 205,000 is going to be charged. He explains what's going to happen. It's going to be charged to the UPC account as of the 31st day of December. Going to be taken to extinguish forever thereafter the annual charge of 8,200 for increased annuities. He doesn't say said increased annuities there. He does say it later. He says increased annuities, and that the UPC, or rather more specifically, the provinces of Ontario and Quebec as representing the late province of Canada, will be relieved from all liability and further payments in respect of the said increased annuities, the increased annuities he's referred to. He makes no reference to $4. He makes no reference to a limit. He asks for an award of this nature. On page 102, he continues at line 5. My application is for an award based on the orders in council for the sum mentioned as finally closing the Robinson Treaty case. And again, the Chancellor says to him, is it necessary to do a separate award? Should we wait for everything else? And he says, no. He says, we want a separate award. It's now completed, line 14, it's now completed. It occurred to me that it would be proper to have an award. This was a special claim brought before this board.
What does this mean to you? Why are you bringing this to my attention?
Because it becomes very important that when there is legislation that says that the final award in writing shall be binding, and he's gone and asked for a final award, that there is a suggestion now today that any issues with that award can be turned around and we can look just at an order in council. They superseded anything else. They got an award. And they knew that their legislation said that that would be binding, and it is binding. They didn't go back for clarification if there was an issue with it. They didn't seek to appeal it. It is legislatively binding on them, and it says what it says. So you can look at surrounding circumstances. In fact, I've told you, I've submitted to you, you need to. The Supreme Court of Canada tells us that. But you can't just look at one surrounding circumstance, the OIC that my friend put before you. It's not the instrument to be used alone. The instrument to be interpreted as Award 15, surrounding circumstances are important, but you have to look at the surrounding circumstances, plural. And all of these have set out, I propose, I suggest, I submit to you, that finality was being sought, and finality was believed to have been achieved. Would it be appropriate to break now before I continue?
Yes, thank you.
This court is stood down for 15 minutes.
All right.
This court is resumed. Please be seated.
Two matters of housekeeping, if I may, Your Honor. The first, you were asking me about what said it was binding, and I told you it was the acts. I will come to discussion, but before we get too much further, perhaps it might be helpful in your notes to note that you can find Canada's Act at tab 2 of our compendium. We will be spending some time with it, but thought that might be helpful if you wish.
Thank you.
The second is Mr. Schachter has helpfully pointed me to a transcription from stage 1 of that Van Coonet to Newcomb letter that I took you to.
Which was that? What tab, please?
He advises me that at the stage 1 trial record 1-1335.
Sorry, it was at what tab? In
Oh, excuse me. That's tab 13, Mr. Van Coonet to Mr. Newcomb.
I'm just finding it in my notes. Take this. Exhibit 1-1335, stage 1.
No, excuse me. If I said 5, I misspoke. I meant 4. 1334. And Mr. Schachter advises me that that is found in both transcribed and signed form at that exhibit.
Thank you. That's very helpful.
Thank you, Mr. Schachter. So I have just a couple more things to say about this request of Mr. Hogg. I'm still at tab 23, Your Honor, and I'm on page 102.
Thank you.
And I think I probably actually could have finished this. I miscalculated how much more I wish to take you to. So let me just say again, or let me just say rather, that at line 20, the Chancellor asks again, do you want a final award? Is this finally settled? You asked for a present and separate award, and Mr. Hogg says yes. So I don't think a suggestion that it was irrelevant or that it was unnecessary. Certainly it was seemed as necessary to Mr. Hogg on behalf, as he indicates at the beginning of his submissions on June the 2nd, 1900, that this was being asked for by all the parties. And the arbitrators, Your Honor, they obliged Mr. Hogg and the other government parties. They gave the award that was asked for. No clarification has been sought about it. I might suggest until now. So suggestions that it's sloppy or imprecise. We have senior counsel here and judges appointed as arbitrators who were asking for it and writing it. It's never been appealed from. We say that Canada must be held to the order that it sought, and that was made in writing and is final.
Thank you.
I'd like to talk a little bit about the debt ceiling. It's been mentioned today. It was mentioned by my friend for Canada in respect of her position that the debt ceiling is something that would also support a $4 limit on a settlement. In Canada, and Professor Messmore argued that it was improbable that the Dominion intended to release annuity obligations above $4 per capita because, and this is what Professor Messmore told us, it would be tantamount to unilaterally increasing the debt allowance for a single province. And that's from her testimony, Your Honor, which you would find at page 199 behind tab 37. But interestingly on that, and you might recall that Professor Messamore and I had a discussion about the debt ceiling and about the different times that it had been raised at different times and for different provinces after Confederation. And she admitted to me on cross-examination that increases to a single province were not unprecedented. So while we say, and certainly Ms. Jones's evidence was that this was nothing to do with the debt ceiling, even if it had been, there were instances that provinces received further grants and further increases to their debt ceiling, notwithstanding Alexander Galt's initial utopic idea that everybody would start off on the same footing.
When you say this had nothing to do with the debt ceiling, the settlement?
Settlement Award 15 cannot be connected in any way to the debt ceiling, or the debt ceiling is not support for an argument that Award 15 was only meant to go up to $4 because somehow the debt ceiling would not permit that.
And your argument is that Ms. Jones gave this opinion.
Ms. Jones gave the opinion that they were just making a decision under their jurisdiction for Indians and Indian matters under 9124 to take this on, appreciating and understanding, of course, that by the time Award 15 is signed, they've got, and we'll come to this next, but you have heard submissions and of course you heard evidence that there's been a number of final binding decisions of the highest courts at the time that this was a 111 matter. 109 is not at play. So it's in the guise of that Canada is responsible for directly paying it. Canada is making a determination, all right, we're going to settle this. We're going to directly pay it. We've been told we have to directly pay it. And we're going to settle for an amount that we can seek indemnification for. It's all related. It all goes back to the Constitution. And what Ms. Jones directly provided testimony directly conflicting with and disputing Professor Messamore's. Professor Messamore said it's a debt ceiling raise, wouldn't do that. Ms. Jones was saying, had nothing to do with the debt ceiling. Here's the reasons why I just explained to you, Your Honor. But what I'm pointing out to you as well, that even if it was an issue about the debt ceiling, which there's no evidence, concrete evidence that there was, Professor Messamore herself admitted to me in cross-examination that increases to the debt ceiling of a single province, and here when I say single province, I mean the single colonial province of the UPC, because of course, Ontario doesn't have its own debt ceiling and neither does Quebec.
Right.
Canada increased the debt ceiling for individual provinces, but she says never happened. But she says to me, and it's in her report, that in fact it did. It did to Nova Scotia in 1869. So Nova Scotia came in with a debt ceiling in 1867, gets increased again just for them in 1869. Everybody's gets increased by the Act of 1873. Manitoba gets a debt ceiling when they joined Confederation in 1870. They solo increase to them in 1885. And those exchanges, talk about this in our main submissions at paragraph 283 in more detail, but it's also at tab 37 at pages 201 and 203 of our compendium. Does Your Honor remember that exchange, or shall we go through it?
I do recall that. Thank you.
And you may recall as well that I took Professor Messamore to a portion of her report where she wrote, and this is at page 127 of her report, of a federal grant that was sort of contemporaneously with the times, 1884, given to Quebec alone, a $2.5 million grant. And in her opinion, she says in her report that the measure, it may have been a measure that had been meant to buy the continued support of Quebec MPs for the Conservative administration. So my point only here is that we don't agree at all that it was a debt ceiling issue. But after Confederation, and despite what I just call the utopic ideals of Mr. Galt and everything was going to be even and it was going to be $25 a person, politicians make decisions all the time and money flows in different directions for different purposes all the time, including settlements. I want, before I go off and leave, I have to cover jurisdiction, but let me talk about releases generally first. Because of course, I began my submissions yesterday by saying that Award 15 is a release. It's a full and final release. And we deal with this in our main submissions at paragraphs 288 and following. And we say, Your Honor, it's our position that the fact that Canada's decision to release Ontario and Quebec may result in more financial exposure than may have originally been contemplated is not a reason to narrowly read the words of Award 15 itself. A party cannot avoid its obligations under a settlement simply because the damages are greater simply because they're greater than they once anticipated. We have authority for that. At tab 4, we've provided the case of Athabasca Realty Company and Foster. It's a 1982 decision of the Alberta Court of Appeal. Paragraph 22 stands for the proposition that I just read to you. This was a personal injury case. The same idea is picked up more recently in British Columbia in a lower court decision, but following Athabasca and the Alberta Court of Appeal in 2013 in a case involving the Gwinitik. I have mispronounced that, I'm sure. I apologize. I can. It's GWINITXW. And that's against the British Columbia Attorney General. And here we see again the concept that party cannot avoid its obligations simply because the damages are greater than the settlement once anticipated they might be. I direct your attention to paragraphs 21 and 25 through 25 of that decision. But perhaps, I don't want to say more importantly, but I think it's important to note that the Supreme Court of Canada has talked about releases quite recently in 2019. That the case that I mentioned to you at the beginning of my submissions this morning, and we've excerpted portions of it at tab 3. It's the Corner Brook City and Bailey case. This was a unanimous decision of the Supreme Court of Canada. It was written by Mr. Justice Rowe. I'll direct your attention to paragraph 27. A release can cover an unknown claim with sufficient language and does not necessarily need to particularize with precision the exact claims that fall within its scope. It goes on to say that in entering into release, the parties bargain for finality, or as Lord Nichols put it, to wipe the slate clean. The releasor takes on the risk of relinquishing the value of the claims he or she might have had, and the releasee pays for the guarantee that no such claims will be brought. So to use the Supreme Court of Canada's language then, Your Honor, by Award 15, Canada took on the risk of relinquishing the value of claims it could have brought then or in the future. And if your question to me earlier was about court orders and judgments, if you were thinking of your own in 2018 and contingent unknown events that might have happened, were they taking on that risk as well? We would say absolutely they were. By its clear language, Award 15 extinguished forever thereafter any claim by the Dominion for increased annuities under the said treaties. We say that this is sufficient language, Your Honor, to cover the plaintiff's claim for augmented annuities in this proceeding. I have a couple of more topics I want to cover, staying in the Ward 15 area. The first is that I wish to address this idea that the arbitrators somehow exceeded their jurisdiction in making this award, that they had no jurisdiction.
One question there. You say this is sufficient language to cover the plaintiff's claim?
This is not about the plaintiff's claim. This is as respect to the direct liability that Canada pays the First Nations, and they can come back to us.
I was asking about your submission.
I'm talking about, because the way that we say the Constitution works and these decisions that bind the government parties before you, Canada has to pay. They have to pay it all. They have direct liability. They have direct liability under the Constitution, and they took it on by Award 15 in addition. If it weren't for Award 15,
I'm
not sure I understand you, then I apologize.
Okay. I thought you said this language is sufficient to cover the plaintiff's claim for
I didn't say that.
augmented annuities, but I believe you mean Canada's claim.
If I said that, I definitely misspoke. The Award 15 is a settlement between the government parties.
Thank you.
So let's talk about December 31st, 1892. Canada says that the award is invalid to be read beyond that, or events or amounts that might accrue beyond that, because the arbitrators had no jurisdiction beyond that to make such an award. Your Honor, December 31st, 1892 was a bookkeeping date. It was used by the parties to facilitate the settlement of the entire UPC account that they were trying to achieve finality on. So to do this justice, pardon the pun, we need to look at the statute, and we need to look at the joint submissions that were placed before the arbitrators pursuant to that statute. So let's start with the statute. It's a compendium tab 2. This is the same statute that I told you about earlier. This is the statute that says that the final award in writing of the arbitrators is binding. But I want to look at the earlier sections of it. It's a very short statute. The previous section that I told you about is section 8. I want to look at the title of the act in section 1 right now. So I'm at page 14 of my compendium.
Thank you.
The act itself, this is Canada's act, and again, it's parallel legislation. Ontario and Quebec passed their own. An act respecting the settlement of accounts between the Dominion of Canada and the provinces of Ontario and Quebec, and between the said provinces. Highlighted section 1, it says, for the final and conclusive determination of such accounts, referring back to the accounts of the Dominion of Canada and the provinces of Ontario and Quebec. Those governments will appoint 3 arbitrators to whom shall be referred such questions as they all agree to submit, as the governments all agree to submit. Following your advice to try to put it in my own words. So we have an act that says they're going to strike an arbitration panel, and you're going to finally do what hasn't been done since 1867 in that award of 1870. Now, the reference to whom shall be referred such questions is given life in what is called the joint submission of the parties being the governments, that's placed before the arbitrators. And if you turn to tab 25, you will find that joint submission. Are you there?
Yes, thank you.
So we see here, I'll try to paraphrase this a bit, but the parties jointly agreed to refer in two here, or in one, all questions relating to or incident to all of these accounts that are still outstanding. Okay, it goes on to say that that's understood to include a number of different things. The relevant one for us, I suggest to you, is D, the claims made by the Dominion government on behalf of Indians and payments made by the government to Indians. Four is what talks about the accounts being brought down and extended in accounting terms to the 31st day of December, 1892. And then the last portion, again, the joint submission to achieve the purpose of the final and conclusive settlement of the accounts, says, it is further agreed that nothing there herein contained is to limit or preclude the parties to this reference submitting such further and other questions or matters as may be mutually agreed upon between the parties. So when you read this joint submission against Section 1 of the Act and the title of the Act, as I said, it's very clear to me that the statutes and the arbitration panel were meant to be the solution to get the job done. It demonstrated that they were intending that all matters pertaining to the accounts at issue would be referred and that a final and conclusive determination would be rendered. And we saw, in fact, just before the break, that Mr. Hogg actually asked for that to happen. He asked for the final winding up, and he asked for something for the future. And he's saying that on June the 2nd, 1900. The future has to extend before not just December 31st, 1892, but indeed well into the future of June the 2nd, 1900, when he asked for that award. Award 15, as you've seen, it's not limited to amounts only owed up to 1892. If you read it in this way, if you interpreted it this way, it's my submission, it would negate the language used of extinguish forever. Extinguish forever contemplates unknown future dates. Reading it so narrowly would also negate the language used in Award 15 that says which may be payable. That language contemplates future unknown amounts. And finally, reading it narrowly would also ignore Mr. Hogg's specific request for an award that we saw to finally close the Robinson Treaty case.
Could you just give me that tab again? I'm not going to go there, but I'd like to make a note of it, of the correspondence from Mr. Hogg.
Oh, I'm happy to. To be clear, what I was just referring to you, though, was we were at tab 23 before the break.
Yes.
And I was referring back to what Mr. Hogg asked for before the arbitrators.
It was in the...
It's at tab 23.
Thank you.
Would you wish for me to find you the correspondence I took you to? And
no, I'm just making a note of that tab again. Thank you.
okay. So that was, yes, that was tab 23. where I took you through that language that I said was so important. I didn't want to paraphrase it too much. I wanted you to have his words. And I would say, Your Honor, it's also important to conceptualize that Award 15 is different than perhaps other settlement awards that some of us in this room may be familiar with. The $205,000, it was not directly changing hands as it might between private parties. The two provinces representing the UPC, the former UPC, they weren't writing a check to Canada for $205,000. That $205,000 was being charged or booked against, and counting language, against the UPC account as of December 31st, 1892. The money then was to be apportioned, that $205,000 booked to the UPC account was to be apportioned and booked against Ontario's account, 52.77% of it, and the Quebec account, the remainder, in accordance with the award of 1870. And then against those amounts, in the individual province accounts, Ontario was charging that 5% simple interest you've heard about. And that was accruing as of December 31st, 1892. So that's the magic about how this was working. And all of this, in fact, is made clear by Hogg, and taking you back in your mind a moment ago when I took you to what Hogg asked for, what he asked the arbitrators for in that final standalone award that he requested. He asked that the balance, reading again from tab 23 at the bottom of page 101 that I took you to. Mr. Hogg says that the balance, the amount of the balance of the said, you can take it back. Are you there?
Yes, I am. Thank you.
So Mr. Hogg says he asked for an award that the amount of the balance of the said account of the province of Canada on the said 31st December 1892, including the above sums, be and on the last day apportioned, divided, and transferred to the separate accounts of Ontario and Quebec on the basis of apportionment established by that award that we call the award of 1870. And that's exactly what happens next. So this is where the bookkeeping becomes important for that date, because it's only a bookkeeping date. Because the award 15, as you've heard, as I'm sure you're well now aware, there were a number of awards by these arbitrators. There's 19 numbered awards in total, along with a number of orders and directions. The burden of proof order is one of them. It's not the only final award in writing that the arbitrator signed on July the 1st, 1900. There's two others signed that day that's relevant to the issues before you, as respect to the government issues before you. And Ms. Jones was the only historian that spoke about these. She wrote about them in her report. And she detailed how awards 16 and 17, and also how award 19, which was a bit later, May 9th, 1901, worked together in her report. So it might be helpful to look at those. If we go to tab 1, and we turn to my page numbering 5, this is award 16.
Okay.
You're there? Okay. So page 5, right-hand side, says it's the 16th award, the 1st August, 1900. This is the award that, page 5 of my numbering, Your Honor.
I'm sorry, I thought you said tab 16.
Oh, excuse me. Tab 1.
Got it.
Page 5, which is award 16.
Thank you.
Okay. So tab 1, page 5, bottom of the right-hand side of that page shows that we're on the 16th award. And again, to paraphrase this all, this is the award that addressed or dealt with the UPC account, or at least the UPC account as of that time. And it ordered that the amounts in the statement of account that the parties had placed before the arbitrators at that hearing that I took you to, the June 2nd, 1900 hearing, and which included the amounts for the Robinson annuities, were to be charged to the UPC account, which is exactly what Mr. Hogg asked for, charged to the UPC account, and then subsequently divided. So we see the language that begins, and I apologize, my mistake, it's not highlighted, but it uses that language on the bottom of the left-hand side of page 6. It's, let me show you.
I see at the very last full paragraph.
The longer of the end paragraphs, and whereas it appears that with the base, in accordance with the basis of apportionment, so they're taking that money and they're saying, okay, $112,350.53 of this total amount of this UPC account is going to be charged to the province of Ontario, and the rest of it, 100,000 and change, is going to be charged as of December 31st to the Quebec account.
There's no controversy at this point, is there?
There's not, but it's important with what comes next and what you haven't been taken to yet in submissions. Ms. Evans for Canada took you to the language at the top of page 6 that talks about this award, award 16, not 15, 16, being without prejudice to certain future events. Okay. Let me address that now before I move on to 17 then. It says that this award is made without prejudice to any claim that the Dominion may have at any time against the provinces of Ontario and Quebec, conjointly in respect of any debt or liability of the late province of Canada not dealt with in the said statement of account, for which subsequent to 31st day of December 1892, the Dominion may be found to be liable. Okay. And then if you turn the page, you see the statement of account or in a portion of it. And remember the language that I just read to you that said that without prejudice to anything that's not in the statement of accounts. And we see here, page 9, left-hand side, that's not page 9. But the Robinson annuities are in the statement of account. So that's my first point. My second point is that another award was signed that day. It's called Award 17. It starts at
So
page
you say
10.
they are in the account, so what do you say?
The without prejudice language doesn't apply. The without prejudice language only covers things that are not in the statement of account.
It does not apply to what? Without prejudice language.
To the extent that Award 16 is talking about the finalization of the UPC account, but without prejudice to things that aren't in the statement of account appended, it cannot be that the Robinson annuities matters can come back to Ontario and Quebec because they are carved out of that without prejudice language, if I may put it that way, by virtue of the fact that they are named and set out in the appended statement of account. And also, of course, we know that Award 15 is a standalone award, asked for and delivered. It has no without prejudice language. Award 17. Ward 17, then, we're going from big to small if we look at 16 and then 17. The big in 16 is the UPC account. 17 is now Ontario's account, and it says what's going to happen there. And it says that those numbers are going to be charged to their account that we just saw. And it says too, at the top of page 10, provided, however, that the said agreement of submission requires the arbitrators to bring down and extend all accounts between the parties as of 31 December 1892, and that certain matters respecting the Common School Fund and the Northwest Angle Treaty Number 3 have not been fully concluded and determined. And recall that there was a reference to that outstanding issue.
I'm sorry, I'm looking at the statement of accounts and looking at where the Robinson treaties are.
Let me take you back to it then, Your Honor. I'm on page 9.
9, thank you.
And I'm on the left-hand column of that double copied page. And you'll see about halfway down, there's a date, 1892,
Yes,
and things were booked in different ways. Here we have a December 31 date,
I see it.
and we see the explicit references to the Huron and Superior Indian Treaty annuities and the capitalization. Then we see as well that that generalized statement in the big 16 of without prejudice to other outstanding matters gets narrowed. In 17, with respect to just Ontario, it's described as being Treaty 3 and Common School Fund, which we know went on for years. And then in 19, which is behind tab 40 of my compendium, this is the award that takes the portion from that bigger award in 16 and applies Quebec's portion of it. And here we have a reference to the Common School Fund still being a carve out. So the idea of that, like in Ontario, so we've got the big 16 UPC, there's some various things that are still outstanding, things that aren't in the said statement of account, but it doesn't specify them. And then I would suggest to you it doesn't specify them globally for the UPC, but it breaks it down into each of the individual provinces' accounts. With 17 against Ontario, they say it's about Treaty 3 and it's about Common School Fund. Treaty 3, of course, is lands in Ontario, what we now think of as Ontario. The Common School Fund is something that is in Ontario or related to Ontario and Quebec issues. So it's specified in 17 for Ontario and in 19 for Quebec. So my submission to you is that those without prejudice language in 16 globally is not just about things that aren't on, well, it says it's not in the statement of account, but also picking up with Ms. Jones' testimony about what it meant. She gave you evidence about these were the things that were still outstanding. They're trying the best as they can to finalize this, but there's still a couple of outstanding things that are still being arbitrated. And in fact, the Common School Fund issue went to the Supreme Court of Canada as well. So they're waiting for resolution on it. And I mean, and it might also be helpful to go back to tab 23 before the arbitrators on June the 2nd, Your Honor. And if we turn up page 102, 102A.
Yes.
Oddly numbered, we were having some problems. Here we see they've moved off of Award 15. Chancellor Boyd has asked Mr. Hogg time and time again, you want a separate award? Yes, we want a separate award. So they've now moved on to the other matters that were originally before them, and they start talking about what they can do about the Northwest Angle Treaty 3. And Mr. Hogg says at the bottom of page 102A that this is still ongoing. Again, I'm happy to read it to you, and if you wish me to, I shall, but he's saying we haven't yet figured this out. We can't have an award today on this. And then the same thing is said by Mr. Trenholm. Mr. Trenholm was counsel for Quebec. He says the same thing at page 102E about the Common School Fund matter. They can't have it dealt with the awards that the arbitrators are dealing with at that point in time. It's not, they're still dealing with it. So these, I suggest to you, are the carve-outs that are, well, specifically set out in awards 17 and 19, but are suggested in award 16 as well. And Ms. Jones gave you ample testimony on that, I would submit. She also told you, of course, that at long last, they actually achieved finality, or they thought they did, because there was a final setting off and closing of Ontario's account. I recall, with some humor perhaps, the exchange that you had with her about triumphantly limping to the end, that they finally settled this all. And a check was issued to Ontario by Canada for the final amount owing of setting off monies that Canada owed for certain smaller trust funds that they were holding and monies that Ontario owed. Ms. Jones talked about that. I have included it. I don't propose going through it with you, but if it becomes important at a later date, it's on compendium tab 35. And the testimony is at compendium page 172 to 175. Your Honor, I plan to move off of Award 15 proper right now, and I'd like to spend quite a bit of time going through the Constitution, what was done in 1867 and leading up to it, and the different decisions made by not just the arbitrators, but the Supreme Court and the Judicial Committee of the Privy Council with respect to them.
Okay.
So I think, in the interest of time, if I may continue to start, I won't get through my first point, but perhaps I can introduce it.
Please go ahead.
So I said yesterday when I began, that it's our position that under the Constitution, Canada is the emanation of the Crown that's responsible for making direct payment for any increased annuities owing to the plaintiffs. And I'll say as a preliminary point that you only need to consider this, we say, if you do not agree with us that Award 15 forever extinguished all obligations that Ontario and Quebec had to Canada to indemnify it for any payments that it may seek from the provinces. And we plead this, you asked for pleading, so let me give them to you. In our amended, or further amended, fresh as amended, statement of defense, you'll find our position, or pleadings rather, set out there at paragraphs 10, 69, 71, 73 through 77, and 95. We've also pled this in our amended defense to Canada's cross-claim against Ontario at paragraph 11, generally and specifically at sub A, E as an echo, and F. In this course of Canada's submissions, there'll be 5 points we hope to develop with you. The first is what I call the financial deal point. And in brief summary, it's that the financial deal of Confederation saw Canada receiving the major revenue sources the colonies had in exchange for assuming direct responsibility for financial obligations that the colonies had entered into prior to Confederation. That's our first point, which will be further developed. The second one is what I call the past judicial determinations point. And it's this, that several judicial determinations conclusively have held that sections 111 and 112 govern the responsibility or liability for Robinson annuity payments. And the converse to that is that section 109 does not. The third point I wish to develop is what I call the de novo point. And I hope to convince you before having to make a de novo argument, but if I do make such an argument, the de novo point is that the same conclusions that were made yesterday must be made today. The fourth point, I call the division of powers point. It's that Canada is responsible for matters relating to Indians under section 9124. And I'll make submissions to you as to why that includes matters of treaty administration, including the payment of annuities. Those are 4 points that I'm going to address. I told you that there was 5. That point will be Mr. Rankin's to take you through. It's what I at least am calling the state successor point. He may give you some other language. And that's in response to Canada's arguments that it's Ontario, we're responding to Canada's argument that it's Ontario, not Canada. That is the successor state to the UPC. And of course, we say the opposite, that it's Canada that is the successor state in this regard, that being annuity payments, and therefore Canada bears the obligation to pay annuities under treaties that were entered into prior to Confederation. My first point is the financial deal. It's probably the shortest of all of them, but I will not get through it in 5 minutes. I probably won't get through it in 15 minutes. Shall I proceed, or should you like to break now?
I don't need to break now. Why don't we?
Can I continue then?
We're good.
Okay. So the financial deal point. Messamore, Coates, and Jones, 3 eminent historians, all testified that Confederation and the Constitution created new entities and created new financial relationships that affected persons and groups with whom the colonial provinces and imperial government had entered financial relationships or agreements with. In terms of the new entities, the UPC ceased to exist. The provinces of Ontario and Quebec came into existence. Don't really plan to spend time on those points. I have included in my compendium, in case it is a point of contention, 2 legal authorities on those points. I will not take you to them. I will refer you to them now, though. One is the JCPC annuities case. We will spend some time on this later, of course. It is at tab 31. And at paragraph 35, the JCPC said this: in 1867, under the Act of Union, the province of Canada ceased to exist, having been divided by that statute into two separate and independent provinces, Ontario and Quebec. On the I thought I said that was paragraph 3. Did I misspeak?
It's 35.
Wow. So tab 31, paragraph 35. Paragraph 3. Thank you. At our compendium in tab 38, we've included the McDonald v. R case. At paragraphs 1 and 4 of that decision, it stands for the proposition that on the 1st July 1867, the province of Ontario came into existence under the British North America Act. So I wouldn't have thought that that's a point of contention between the parties, but if it is,
I'm sure it's not.
thank you, Your Honor.
Well, I'm sure the words on the page are the words on the page.
The words on the page are the words on the page. I'd like to talk then about the financial relationships. Dr. Messamore, Dr. Coates, and Ms. Jones all agreed. Again, these are the words on the page and the titles and headings in the Constitution Act itself, that the financial provisions, as we think of them, in the Constitution Act are those set out between sections 102 and 118 of the British North America Act. And they all agreed with the various people who questioned them that those provisions, that financial arrangement was, they used the words long debated, deliberately negotiated. Dr. Coates said that it was a business deal built on compromise. Do you wish the references to the transcript for those, Your Honor?
I do not, thank you.
They all agreed that the financial deal gave the new provinces most land with which they entered confederation and certain revenues relating to the lands. That's section 109 as we now know it. The new financial deal also gave to the new provinces the right to receive certain subsidies and grant monies in order to be able to carry out the functions of government that they were going to be responsible for going forward. That's section 118, as we now think of it. It was repealed, not in a time frame, though, that's relevant to this case, I would submit. What did it give to the new Dominion government? Well, you heard a lot of evidence about that too. And most importantly, we say it gave the colonies previously existing right to impose custom duties and taxes, direct taxes, gave all of that to the new Dominion. That's what became section 102 from the various resolutions you heard about. And the historians all agreed, it was undisputed, that those duties and direct taxes were the primary revenue source for all of the colonies entering Confederation. That's where they got their money from.
Reconfederation.
Entering into Confederation, the colonial provinces, that's where they made their money. That's how they funded themselves. As of June 30th, 1867, that was going to the colonies. The very next day at midnight, it's all going to Canada. And it's flowing into 102, section 102 tells us, directs that it flow into a new consolidated revenue fund to be established of the Dominion of Canada. I also have transcript references for that if you wish. I should tell you, maybe it's easiest if I tell you that Messamore, Professor Messamore, everything that I'm saying that she has said, the excerpts are at tab 37 relating to,
Maybe the paragraphs in your submissions.
I will certainly provide those for you. I'll get those for you in the break.
Thank you.
But I'll tell you that Professor Messamore's excerpts, when I say that she
37.
said, it's at tab 37. Dr. Coates is at tab 36, and Ms. Jones is at tab 35.
Thank you.
So you also heard that these historians agreed or provided reports that in exchange for receiving those revenue sources that had been the colonial provinces alone prior to Confederation, in exchange for receiving them as of July the 1st, 1867, Canada became the sole entity liable to directly discharge all debts and liabilities of the colonies existing at the Union, existing at Confederation. In January of this year, Your Honor, when I stood to give Ontario's opening statement, I called this as being Canada became the port of first call. And that's the way that I think of it, that the financial obligations that the colonies had were now Canada's. They couldn't go out after July the 1st, 1867 and take on new contracts, new obligations, but obligations that existed at the Union that had been entered into, that had been agreed, contingent or otherwise. Mr. Marcello will spend some time in particular talking to you about contingent liabilities. What existed at the Union became Canada's. And we see then the language of Section 111 that tells us exactly what I just told you. Canada shall be liable for the debts and liabilities of each province existing at the Union. There's two other provisions that you've heard an awful lot about. One is Section 112. One is Section 142. As part of the financial deal of Confederation, Section 112 granted Canada a right to seek indemnification from Ontario and Quebec for 5% interest on the amount that the UPC's joint debt exceeded the debt ceiling then set out, 62.5 million. And then a further act increases it. There's no contention about that point, I believe. And finally, the court heard testimony about Section 142. And I should say as well that all of these provisions, if it's convenient, that I've referred to, we've set them out in our compendium at tab 26 for ease of reference. But Section 142 very explicitly, very exclusively assigned the responsibility for dividing Ontario and Quebec's former UPC assets and debts to a panel of arbitrators. And you heard an awful lot about how that went, some ways better than others. And they did so. They apportioned that liability in their final award of September 3, 1870. Now that brings me into the next point I want to develop with you, which is the binding past judicial determinations, because the award of 1870 is one of those. Should I continue or should
Why
I?
don't we take a break now?
Then that's a good cliffhanger until after lunch.
How are you doing with your time?
I am a little more than halfway through.
Are you where you hoped or expected to be?
Well,
Hope is
the
always
question is, should we come back
aspirational.
at 1:45?
Compromise, say 10 to 2. Settlements are all about compromise.
Excellent. We'll come
10
back.
to
at
2.
10 to
Thank you.
2.
We're all right.
Court is stood down until 1:50.